Lawyers can be regulated for things that they say. And we're going to talk here about the constraints that exist in relation to lawyers' public statements, their general obligation of civility, and then how that obligation plays out in two particular contexts: when lawyers are critical of other lawyers and when lawyers are critical of judges and the legal system. In looking at these concepts, the important thing to bear in mind is that in every context, the focus of regulation is considering lawyers' obligation to represent the interests of their client, their obligation to advocate for their clients, and yet the need to ensure civil discourse to maintain a fair and appropriate administration of justice. One can argue about whether we get the balance right in all of these cases. From some time to time, I personally think we don't, but that overarching policy objective is clear, it's reflected in the law, and the only question is whether we get it right most of the time. In terms of public statements, you'll see in the codes of conduct that, in essence, we permit lawyers to make public statements, but we want them to do so in a way that properly advances the interests of their clients, rather than being about the lawyer's own aggrandizement. So you'll see there that they can make statements, but they need to actually serve the client's interests and be within the scope of the retainer. They have to respect confidentiality, and they cannot be about publicizing or promoting the lawyer. And of course, they cannot violate other legal obligations, such as you can't be defamatory and you can't prejudice the legal proceedings where the statement's being made. Lawyers have been disciplined for public statements where they breach loyalty and confidentiality, and the courts have recognized the possibility for a defamation suit. However, consistent with my point about respecting the lawyer's role as an advocate, courts will take into account that sometimes lawyers have to say critical things that might otherwise be perceived as defamatory as part of their legal obligation to advance the interests of their client. The general duty of civility for lawyers is reflected clearly and consistently through the case law, that when you act as an advocate, you're supposed to be civil in terms of everyone you're dealing with, in terms of serving clients, in terms of how you treat tribunals, and you must not engage in rude, provocative, or disruptive conduct. Lawyers have been disciplined for incivility. It doesn't happen very often, but that incivility can be directed or be disciplined for a lawyer can be disciplined for having directed that incivility at a wide range of people, from the lawyer's own client to a self-represented litigant to an opposing party. If you look at the cases on incivility, as I said, they're not very common, and a lot of them are about a lawyer engaging in bullying behavior to another person in a way that's not just about the rudeness of the lawyer, but also reflects a lawyer's improper use of their position and authority. Criticism of other lawyers. Again, there are the general duties of courtesy and civility, which would make it improper for a lawyer to breach those duties in relation to another lawyer. There are also requirements that you must not make ill-considered or uninformed criticisms of other lawyers. And also, and this is a more positive duty, that you ought not to take advantage of slips or oversights by the other side. So part of it's about being polite and fair in your dealings with other parties, and part of it is about not exploiting another party's mistake. I'm going to talk in particular with criticisms of lawyers with two cases. One, the Lariker case, which to my mind is a problematic decision, and the other is Groya, which used to be a problematic decision, but in my view has now been dealt with appropriately by the Supreme Court of Canada. So in Lariker, the lawyer became aware of the kind of demand letters that we see or saw in the Zellers case, where a demand letter is sent to the parents of shoplifters, and the legal basis for that letter is not there, and arguably the letter is being sent to obtain payment from someone without a legal basis. Lariker responded to one of those letters by writing a response to the lawyer who sent it, and you can see on the slide here the content of the letter, that it was very rude, telling him to put the letter to the only use for which it might be suitable. And Lariker was disciplined for incivility in relation to sending that letter. And the Law Society of British Columbia said, your feelings about the other lawyer and about what the lawyer was doing was irrelevant, and it didn't matter if that lawyer was a rogue, because vigilante justice in the form of a rude letter was not appropriate. And they fined Lariker $1,500 and had him pay $1,500 in costs. I have concerns with this decision. I don't think that what Lariker said was inappropriate given the content he was dealing with. Yes, he could have expressed it more politely, but at the end of the day, when the substance is appropriate, I think there are real issues with disciplining a lawyer simply because they didn't use as elegant or eloquent words as they could have. And it's particularly important for lawyers to call out the kind of misconduct that was being dealt with by Lariker in that case, when he saw a letter being sent to someone without legal foundation in an attempt to obtain payment, even though that foundation was not there. There are other cases where lawyers have been disciplined for what they said. Two other lawyers, as you can see here, in many cases what was said was much more, was very significant and very problematic. And in some of these cases where what's said is more mild, the incivility is coupled with other forms of professional misconduct. So you need to be aware of that when you look at these examples. Now let's talk about Groya. So the basic facts of Groya are that he alleged that the prosecutor in the case of Felderhoff, where he was acting, was engaged in prosecutorial misconduct. He made allegations to that extent at various points in the trial. And he also made those allegations in a way that was sarcastic and rude. And there's a few examples here. Now, at no point, though, during that prosecution was he sanctioned by the trial judge, and there was no complaint to the Law Society. However, in interlocutory proceedings that occurred during the Felderhoff trial, Groya's conduct was raised, and those courts were critical of him. He was not a party to those motions, and no arguments were made to defend his conduct during those motions. And his side, his client, Felderhoff, was successful in those motions, but in the course of their reasons, both the Ontario Court of Appeal and I believe the Divisional Court were quite critical of Groya and also of the prosecutor. In response to those interlocutory motions, the Law Society initiated disciplinary proceedings against Groya. Now, he was unsuccessful. He was found guilty of professional misconduct at every level prior to the Supreme Court of Canada. At a disciplinary hearing, he was found guilty of professional misconduct, required to pay almost $250,000 in costs, and given a 2-month suspension. That was upheld at the appeal panel in the result, although they used a very different test for incivility, and they reduced his suspension to 1 month. The Divisional Court and the Ontario Court of Appeal upheld the misconduct decision and, to a greater or lesser extent, approved of the test that the appeal panel used for incivility. Groya then appealed that decision of the Ontario Court of Appeal to the Supreme Court of Canada, where he was successful. But they basically say that the appeal panel's test for incivility was correct, but that the way the appeal panel applied that test to Groya was unreasonable and needed to be overturned. Now, because the appeal panel test for incivility is upheld by the Supreme Court and is very important, I do want to note it here. The appeal panel said that incivility is something that is not just merely being rude or being discourteous. It cannot be applied in a way that discourages advocacy, and that in every case, especially when you're looking at in-court incivility, you have to look at the lawyer's behavior in a way that is contextual and fact-specific. And you'll see here the key quotation from paragraph 233 of the Law Society's decision, where they point to the need for that contextual and fact-specific approach. And they note the pressure that advocates can be under, that these are very complex matters, and you can't look at just one outburst of temper or inappropriate language to find incivility, and that you can look at the context of the behavior of the other lawyers and what was occurring with the trial judge as well. As I said, the Supreme Court upheld the appeal panel's test as reasonable, and they pull out of the appeal panel test 4 factors that are particularly important, although not exclusively important. What the lawyer said, the manner and frequency of what was said, the presiding judge's reaction, and the lawyer's behavior. The reason why the appeal panel test was reasonable is, first of all, it recognizes that civility is important, that incivility is prejudicial to clients and to the administration of justice, and that civility is a positive value in the legal system. In addition, the appeal panel properly accounted for the lawyer's role as advocates. It balanced freedom of expression with a statutory mandate. It set a high enough threshold not to chill fearless advocacy, and it's both flexible and precise in communicating to lawyers what is required, while also allowing the Law Society to take into account the particular circumstances of that lawyer's conduct. It also, the Supreme Court found, and in my view, they actually do narrow what the appeal panel did, but as narrowed, they said that the appeal panel has properly developed a test for assessing comments made by one lawyer about another in court. And they said for professional misconduct to occur, allegations made about another lawyer must be made in bad faith and without a reasonable basis. Or to put it differently, a challenge to an opposing counsel's integrity must be made in good faith and have a reasonable basis. However, the court said, and this is where I think they narrow what the appeal panel did, they said a reasonable basis does not require the allegation to be sound in law. The lawyer can make a mistake about what constitutes misconduct legally and still have a reasonable basis, provided that the allegation is not speculative and provided it has a factual foundation. In addition, they said that in looking at incivility in the context of making an allegation about another lawyer, you have to take into account that every time you make an allegation about another lawyer, it's going to have strong language. It's going to be necessarily critical and in that sense uncivil. So the key thing is, was the lawyer acting in good faith? And did the allegation they make have a reasonable basis in the sense of not being speculative and having a factual foundation? And are you taking into account the fact that they're using strong language in a context where strong language will be required? The court also emphasized the appeal panels properly accounting for the nature of what's being said, how frequently, and the content, and also looking at both what judges say and how the lawyer responds. Those are things that ought to have been looked at by the appeal panel and taken into account, and were. However, on the appeal panel's own test, the Supreme Court held or found that it was unreasonable to say that Joe Groya committed professional misconduct. They noted that the appeal panel itself assumed or conceded that Groya was acting in good faith, and the Supreme Court said he had a reasonable basis for his position, even though that position was based on a legal error. His view of the law and the facts as they actually were sufficient to give his allegations a reasonable basis. And the court says, a sincerely held but erroneous legal belief is not enough to find that a lawyer has committed incivility. In terms of the frequency of Groya's allegations, they said that followed in significant part from the uncertainty in the law and abusive process, and also in terms of what the trial judge was doing. They noted that Groya responded appropriately and fully to any direction given by the trial judge, and they acknowledged Groya's sarcasm and his occasional petulant invective, which is something one of the interlocutory courts said. But they said in the broader context, that was not sufficient to ground a finding of prosecutorial misconduct. And here you see at paragraph 160 a summary of the majority's position on this. The view of the dissent in this case is primarily that the appeal panel's test, as properly understood, narrowed as it was by the majority in their view, but the appeal panel's test, as properly understood, was reasonable, and their application of that test to Groya in the broader context of his conduct was also reasonable. But the majority took the position set out here. Now let's look finally at incivility in the context of criticizing judges and the legal system. And here you see in the codes of conduct an emphasis on the point that lawyers do need to criticize legal decisions and what judges do, but an emphasis on the requirement that those criticisms not be petty or intemperate, and that lawyers are supposed to support tribunals when those tribunals are unfairly or unjustly criticized. And the one case you have on this issue from the Supreme Court is Dore, and in that case, the lawyer wrote a letter which is sort of magnificent in its rudeness to the judge, who had himself been very rude to Dore. The judge was reprimanded for his treatment of Dore, but Dore was also found guilty of professional misconduct, and the Supreme Court upheld that. And you see here a general definition of incivility, which I think infuses all contexts, which is that it is a potent display of disrespect for the participants in the justice system beyond mere rudeness or discourtesy. Again, an emphasis on that being fact-dependent and discretionary. And again, an emphasis on the regulator's requirement that they balance the need for forceful criticism of public institutions with the need to ensure civility. So to return to where I started, the key point on lawyer speech is that whatever comes out of a lawyer's mouth should be directed at advancing the client's interests, must respect the client's confidentiality and rights in that respect in terms of the representation in the legal system as a whole, and also should be oriented towards ensuring that the administration of justice functions appropriately and effectively. So advocate for your clients, respect their rights and interests, and ensure the fair administration of justice.